A lawsuit alleging election fraud and voter fraud was dismissed in Michigan on Friday, November 13th. Hi, my name is Wes Austin. I'm a lawyer and comedian. Normally in my channel we talk about legal news, funny patents, funny trademarks, and stand-up comedy. Today we're going to find out what happened in Michigan. First, we are going to identify the lawsuit just so that you know which one this is. This is not one of the lawsuits that have been filed by Donald Trump. And then we're going to look at the opinion from the judge and go over his reasoning on why he dismissed these claims with regard to election fraud and voter fraud. All right? So here is a copy of the complaint. As you can see here, this was filed by Cheryl A. Costantino and Edward P. McCall. And it was filed against the City of Detroit, Detroit Election Commission, Janice M. Winfrey in her official capacity as the clerk of the City of Detroit, and the chairperson of the Detroit Election Commission, Kathy M. Garrett, in her official capacity as the clerk of Wayne County, and the Wayne County Board of Canvassers. All right? So that is the lawsuit we are talking about, and it was filed on November 9th. Now let's look at what the claims were they made in this complaint before we get over to the judge's opinion. All right, count 1. Constitutional right to accuracy and integrity of elections under the Michigan Constitution. Count 2, statutory election fraud. Count 3 is common law election fraud. Count 4 is an equal protection violation under the Michigan Constitution. And count 5 were statutory election law violations under various provisions of Michigan state law. Am I saying Michigan weird? Michigan. I feel like I'm saying Michigan weird. Don't send me messages about it. Michigan. All right, now let's go ahead and look at the opinion from the judge. I should clarify. A lot of people are saying this case was dismissed. Technically, it wasn't dismissed. He denied the requests for preliminary injunction in the opinion, but this case isn't officially closed, so it wasn't really dismissed. All right. This opinion came out Friday, November 13th. So Friday the 13th. So the plaintiffs in this case were requesting a preliminary injunction. So that's the posture of this case. Now, if somebody's asking for a preliminary injunction, you have to meet certain criteria. You have to pass certain requirements in order to get this preliminary injunction. And that's the first thing the judge talks about. When considering a petition for injunction relief, the court must apply the following four-pronged test. 1, the likelihood the party seeking the injunction will prevail on the merits. 2, the danger the party seeking the injunction will suffer irreparable harm if the injunction is not granted. 3, the risk the party seeking the injunction would be harmed more by the absence of an injunction than the opposing party would be by the granting of the injunction. And 4, the harm to the public interest if the injunction is issued. Also, on preliminary injunctions, injunctive relief represents an extraordinary and drastic use of judicial power that should be employed sparingly and only with full conviction of its urgent necessity. So what this means is, like, courts really don't want to grant preliminary injunctions unless you really, really have to have one. So you don't have alternative remedies, and you kind of balance the factors here, but it's only in extreme cases are they going to grant someone a preliminary injunction. Okay, so as evidence, the plaintiffs had filed 7 affidavits claiming various kinds of voting irregularities and election fraud. So in their defense, the defendants, which would be the City of Detroit and the officials of Wayne County, they filed 6 affidavits. So trying to give their reasons and counter evidence to what the plaintiffs were asserting. So the judge is going to tell us just generally what he thinks in this brief paragraph, and then he's going to go through each one of these affidavits from plaintiff and basically tell us why he didn't like them. Tell us why he didn't believe them. So first we're going to look at what he said generally, and then we'll look at his specific language for each one of these affidavits. So again, this is in the opinion that came out November 13th. After analyzing the affidavits and briefs submitted by the parties, this court concludes the defendants offered a more accurate and persuasive explanation of activity within the absent voter counting board, AVCB, at the TCF Center. So, he thinks the defendants were more accurate and persuasive in their reasoning for what happened. And he kind of just didn't really believe what the affidavits from the plaintiffs were saying. I need to stop playing because this makes the noise and I can't help it. So the judge is first going to look at the affidavit from Jesse Jacob. Jesse Jacob asserts Michigan election laws were violated prior to November 3rd, 2020, when City of Detroit election workers and employees allegedly coached voters to vote for Biden and the Democratic Party. Ms. Jacob, a furloughed city worker temporarily assigned to the clerk's office, indicated she witnessed workers and employees encouraging voters to vote a straight Democratic ticket, and also witnessed election workers and employees going over to the voting booths with voters in order to encourage as well as watch them vote. Ms. Jacob additionally indicated while she was working at the satellite location, she was specifically instructed by superiors not to ask for driver's license or any photo ID when a person was trying to vote. So generally, the judge, looked at her affidavit. He kind of characterized it right there. And now he's going to tell us the problems that he sees with this affidavit. The allegations made by Ms. Jacob are serious. In the affidavit, however, Ms. Jacob does not name the location of the satellite office, the September or October date these acts of fraud took place, nor does she state the number of occasions she witnessed the alleged misconduct. Ms. Jacob in her affidavit fails to name the city employees responsible for the voter fraud and never told the supervisor about the misconduct. Ms. Jacob's information is generalized. It asserts behavior with no date, location, frequency, or names of employees. In addition, Ms. Jacob offers no indication of whether she took steps to address the alleged misconduct or to alter any supervisor. Oh, that's got to be a typo. Alleged misconduct, or has to be notify any supervisor about the alleged voter fraud. Ms. Jacob only came forward after the unofficial results of the voting indicated former Vice President Biden was the winner in the state of Michigan. The judge goes on. Ms. Jacob also alleges misconduct and fraud when she worked at the TCF Center. She claims supervisors directed her not to compare signatures on the ballot envelopes she was processing to determine whether or not they were eligible voters. She also states that the supervisors directed her to predate absentee ballots received at the TCF Center on November 4th, 2020. Ms. Jacob ascribes a sinister motive for these directives. Now, the judge is going to start looking at an affidavit from the defendants, trying to give reasons for what was going on and their version of what happened. All right? So now we're going to turn to one of these affidavits. Evidence offered by longtime state elections director Christopher Thomas, however, reveals there was no need for comparison of signatures at the TCF Center because eligibility had been reviewed and determined at the Detroit Elections Headquarters on West Grand Boulevard. Ms. Jacob was directed not to search for or compare signatures because the task had already been performed by other Detroit city clerks at a previous location in compliance with MCL 168.765A. As to the allegation of predating ballots, Mr. Thomas explains that this action completed a data field inadvertently left blank during the initial absentee ballot verification process. Now the judge goes to the next affidavit, which was from Andrew Saito. Andrew Saito was a Republican challenger who did not attend the October 29th walkthrough meeting provided to all challengers and organizations that would be appearing at the TCF Center on November 3rd and 4th, 2020. Mr. Saito offers an affidavit indicating that he heard other challengers state that several vehicles with out-of-state license plates pulled up to the TCF Center at approximately 4:30 a.m. on November 4th. Mr. Saito states that tens of thousands of ballots were brought in and placed on 8 long tables, and unlike other ballots, they were brought in from the rear of the room. Saito also indicated that every ballot that he saw after 4:30 a.m. was cast for former Vice President Biden. Okay, are you wondering what the judge thought of this affidavit? He's going to tell us. Mr. Saito's affidavit, while stating a few general facts, is rife with speculation and guesswork about sinister motives. Mr. Saito knew little about the process of the absentee voter counting board activity. His sinister motives attributed to the city of Detroit were negated by Christopher Thomas's explanation that all ballots were delivered to the back of Hall E at the TCF Center. Thomas also indicated that the city utilized a rental truck to deliver ballots. There is no evidentiary basis to attribute any evil activity by virtue of the city using a rental truck with out-of-state license plates. Mr. Saito contends that tens of thousands of ballots were brought in to the TCF Center at approximately 4:30 a.m. on November 4th, 2020. A number of ballots speculative on Mr. Saito's part, as is his speculation that all of the ballots delivered were cast for Mr. Biden. It is not surprising that many of the votes being observed by Mr. Saito were votes cast for Mr. Biden in light of the fact that former Vice President Biden received approximately 220,000 more votes than President Trump. It seems kind of circular to me, that reason does. Just because it seems like he's saying, well, a lot of the votes were for Joe Biden because a lot of the votes were for Joe Biden. So, I mean, it seems a little circular to me, but... All right, next we go to the affidavit of Daniel Gustafson. Daniel Gustafson, another affiant, offers little other than to indicate that he witnessed large quantities of ballots delivered to the TCF Center in containers that did not have lids. Okay, there's a few typos in this opinion, so it's not me, it's them. Anyway, delivered to the TCF Center in containers that did not have lids that were sealed or did not have marking indicating their source of origin. Mr. Gustafson's affidavit is another example of generalized speculation fueled by the belief that there was a Michigan legal requirement that all ballots had to be delivered in a sealed box. Plaintiffs have not supplied any statutory requirements supporting Mr. Gustafson's speculative suspicion of fraud. Yeah, so the judge is saying nobody said these boxes had to be sealed, so it doesn't matter that they weren't sealed. Now, in another affidavit, someone said that they thought some of the computers were connected to the internet, which was a problem. Now, this is what the judge had to say about that. Mr. Colbeck implies that there was internet connectivity because of an icon that appeared in one of the computers. Christopher Thomas indicated computers were not connected for workers, only the essential tables had computer connectivity. Mr. Colbeck, in his affidavit, speculates that there was in fact Wi-Fi connection for workers' use at the TCF Center. No evidence supports Mr. Colbeck's position. And also, it looks like the judge or someone, maybe one of the defendants in their affidavits, had been looking at Mr. Colbeck's Facebook page, because then the judge said this. This court also reads Mr. Colbeck's affidavit in light of his pre-election day Facebook posts. In a post before the November 3rd, 2020 election, Mr. Colbeck stated on Facebook that the Democrats were using COVID as a cover for election day fraud. His predilection to believe fraud was occurring undermines his credibility as a witness. So be careful what you post on Facebook, because a judge might look at it. So, which is probably why I should not be posting this on Facebook. Now the judge moves on to the next affidavit, and this affidavit actually somewhat relates to the Dominion voting software that everybody's been talking about. This just has a little tie into that. So anyway, let's move on to this next affidavit from the opinion. Melissa Carone was contracted by Dominion Voting Services to do IT work at the TCF Center for the November 3rd, 2020 election. Ms. Carone, a Republican, indicated that she witnessed nothing but fraudulent actions take place during her time at the TCF Center. Offering generalized statements, Ms. Carone described illegal activity that included untrained counter-tabulating machines that would get jammed 4 to 5 times per hour, as well as alleged cover-up of loss of vast amounts of data. Ms. Carone indicated she reported her observations to the FBI. This is what the judge says. Ms. Carone's description of the events at the TCF Center does not square with any of the other affidavits. There are no other reports of lost data or tabulating machines that jammed repeatedly every hour during the count. Neither Republican nor Democratic challengers nor city officials substantiate her version of events. The allegations simply are not credible. Ouch, that hurt. All right. The last affidavit that they looked at was from an attorney, Zachary Larson. So let's look and see what the judge said about this. Lastly, plaintiffs rely heavily on the affidavit submitted by attorney Zachary Larson. Mr. Larson is a former assistant attorney general for the state of Michigan who alleged mistreatment by city workers at the TCF Center as well as fraudulent activity by election workers. He expressed concern that ballots were being processed without confirmation that the voter was eligible. He expressed concern that he was unable to observe the activities of election official because he was required to stand 6 feet away from the election workers. He also says that he was excluded from the TCF Center after leaving briefly to have something to eat on November 4th. He expressed his belief that he had been excluded because he was a Republican challenger. Now, here's what the judge says about that. Mr. Larson's claim about the reason for being excluded from re-entry into the absent voter counting board area is contradicted by 2 other individuals. Democratic challengers were also prohibited from re-entering the room because the maximum occupancy of the room had taken place. Given the COVID-19 concerns, no additional individuals could be allowed into the counting area. Democratic Party challenger David Jaffe and the special consultant Christopher Thomas in their affidavits both attest to the fact that neither Republican nor Democratic challengers were allowed back in during the early afternoon of November 4th as efforts were made to avoid overcrowding. Mr. Larson's concern about verifying the eligibility of voters at the AVCB was incorrect. As stated earlier, voter eligibility was determined at the Detroit election headquarters by other Detroit city clerk personnel. The claim that Mr. Larson was prevented from viewing the work being processed at the tables is simply not correct. As seen in the City of Detroit exhibit, a large monitor was at the table where individuals could maintain a safe distance from poll workers to see what exactly was being performed. Mr. Jaffe confirmed his experience and observation that efforts were made to ensure that all challengers could observe the process. Now, the judge also said this. It is noteworthy as well that Mr. Larson did not file any formal complaint as the challenger while at the AVCB. Given the concerns raised in Mr. Larson's affidavit, one would expect an attorney would have done so. Mr. Larson, however, only came forward to complain after the unofficial vote results indicated his candidate had lost. So now the judge is going to give them the specific reasons why their request for a preliminary injunction is going to be denied. As stated above, plaintiffs have multiple remedies at law. Plaintiffs are free to petition the Wayne County Board of Canvassers, who are responsible for certifying the votes. Fraud claims can be brought to the Board of Canvassers, a panel that consists of 2 Republicans and 2 Democrats. If dissatisfied with the results, plaintiffs also can avail themselves of the legal remedy of a recount and the Secretary of State audit pursuant to the statute. This court finds that there are legal remedies for plaintiffs to pursue, and there is no harm to plaintiffs if the injunction is not granted. There would be harm, however, to the defendants if the injunction is granted. waiting for the court to locate and appoint an independent, nonpartisan auditor to examine the votes, reach a conclusion, and then finally report to the court would involve untold delay. It would cause delay in establishing the presidential vote tabulation as well as other county and state races. It would also undermine the faith in the electoral system. I mean, that reason, it would also undermine faith in the electoral system. I don't know that I think that's a great reason. Like if there are problems with an election process, if there happen to be any kinds of fraud, you wouldn't want to say, well, we shouldn't really check into it because that would undermine the integrity of our system. All right, and here is the conclusion from the judge. Plaintiffs rely on numerous affidavits from election challengers who paint a picture of sinister fraudulent activities occurring both openly in the TCF Center and under the cloak of darkness. The challengers' conclusions are decidedly contradicted by the highly respected former state elections director Christopher Thomas, who spent hours and hours at the TCF Center November 3rd and 4th explaining processes to challengers and resolving disputes. Mr. Thomas's account of the November 3rd and 4th events at the TCF Centers is consistent with the affidavits of challengers David Jaff, Donna McKenzie, and Jeffrey Zimmerman, as well as former Detroit City election official, now contractor Daniel Baxter, and the City of Detroit Corporate Counsel Lawrence Garcia. Perhaps if plaintiff's election challenger Affiance had attended the October 9, 2020 walkthrough of the TFC Center ballot counting location, questions and concerns could have been answered in advance of the election day. Okay, that was kind of that had a little sting to it, didn't it? If you guys would have shown up like you were supposed to, you probably would have known what's going on. Like, that's how I picture the judge saying that to them. Regrettably, they did not, and therefore plaintiff's Affiance did not have a full understanding of the TCF absent ballot tabulation process. No formal challenges were filed. However, sinister fraudulent motives were ascribed to the process in the City of Detroit. Plaintiff's interpretation of events is incorrect and not credible. Incorrect and not credible. So not credible means he doesn't believe them. He doesn't think they're telling the truth. I don't know if he says they're liars, but I mean, when you say they're not credible, he's saying he just doesn't believe them. All right, he does not believe what they're saying, obviously, from this opinion. Plaintiffs are unable to meet their burden for the relief sought, and for the above-mentioned reasons, the plaintiff's petition for injunctive relief is denied. The court further finds that no basis exists for the protective order for the reasons identified above. Therefore, that motion is denied. Finally, the court finds that this statute governs the audit process. The motion for an independent audit is denied. You can see that this was Friday the 13th, November 13th, 2020. By the Judge Timothy M. Kenny. All right, so that is what happened to that voter fraud lawsuit in Michigan. Again, this is just recent, November 13th, just last Friday. I'll try to keep you posted, and we'll see you again next week.